Morning,
Okay.
Ms.
There are some people that we don't need for the court calendar. If Ms. Kim can please let me know and
Yes.
call you.
They are waiver of arraignment and they're pleading not guilty. So it will be Robert Cheney, we don't need him here, and Kristen Collier, Kivia Gonzalez.
Ms. Kim, can you give us the position numbers? That kind of
Oh
works.
yeah, absolutely.
It's 9 o'clock.
Number 9, position number 9, Chance. Position number 11, Collier. Position number 16, Gonzalez. That's it. Thank you.
9, 11, and 16.
Yes, and I was not able to speak to Sharquita Townsend. I waited more than twice and nobody showed up. So does she have a private attorney? Otherwise, I would like to interview. Oh, Officer Milton.
Yes.
I waited Miss Sharquita Townsend twice. I tried to have an interview with her, but I was not able to reach. Nobody showed up. Does she have a private attorney?
Do you have a private attorney, Ms. Thompson? She said no.
Okay, I'll be happy to if she calls me, I'll be happy to talk to her.
Okay. All right. Have a seat down there for me, please. I'll get to you. And who's the other one, Lewis? Miss Lewis, she said she needed some paperwork signed.
Yeah, but I can take care of that part here.
Okay. What about Quinetta Jones and Miss Hall? Do you still need those?
Miss Jones is PD Bartle's client, and it's my understanding he emailed me last night and said that's going to be a plea, so we will need her.
Okay. What about Quinetta Jones?
Yes, that's who we need. That's whose client is PD Bartle's. Yeah.
Okay.
Who is the other person?
Tajma Hall.
I mean, I don't know.
That is also, I think that's also PD Patel. Patel's is there at the courtroom too, so maybe he can answer for us.
Morning, Judge. Yeah, Ms. Hall.
Okay. Yes, Mr. Barker.
Yes, Ms. Hall will be a reset. We don't need her brought out unless she wants to see the judge. We need Ms. Jones, Quinetta Jones. That will be a plea.
Second row.
Okay. So, Ms. Townsend, you have a seat down there. Miss Attorney Kim, we're gonna call you right now. For
Okay,
Ms. Townsend.
sounds good. Thank you.
Ms. Kim, before you go, just for clarification, position
Sure.
number 8 is Gary Chancey. Position number 9 is Robert Cheney. On your announcement form, you have position number 8, Gary Chance, was a waiver.
Oh, he is also not needed for the court. He is PD Tom White's client.
Okay, thank you. Okay, so
Morning, Judge.
good morning. How are you doing today?
Good. I hope you're doing well.
Thank you. I am. Who do we have?
We're going to start with position number 22, Miss Lewis.
Okay, and let me just address that all the ladies that are there at the ACDC. Good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. If you do not have a private attorney, we're providing you with the assistance of a public defender today if you would like to utilize their service. Let's see, Ms. Lewis, good morning again. You've been charged in case 24 CR 006466F with theft by shoplifting. What are we doing with Ms. Lewis this morning? Who's representing Ms. Lewis?
I do, Your Honor. It is non-negotiated plea, Your Honor. We just want to make sure if we can waive $500 fine.
Okay. So the $500 fine is the only thing that's in contention?
Yes, Your Honor.
Okay, would you agree to as opposed to waiving it to a 50 hours of community service as opposed to a $500 fine?
We don't mind that as long
Okay.
as solicitor does not object.
Ms.
Your
Desi,
Honor, we don't object to that. And I was actually going to propose, so this incident, the defendant was shoplifting bottles of wine. Her criminal history, Your Honor, this is her third shoplifting offense. It's actually probably her fourth or fifth. And of course, after the third, it's a felony. However, I couldn't verify the disposition on one of her other shoplifting. So the basis for the fine is because of her record. However, she does have several DUIs in her history as well. And in this case, she's accused of stealing wine from CVS. So what I was going to propose, if the defense is amenable, is instead of the fine, we could do like AA meetings a couple times a week instead, or community service is also fine. But we did recommend that she was going to do 40 hours of community service already. So if we convert the fine to community service, then she would be doing, I guess, 90 hours of community service.
Is that gonna be okay, Miss Lewis? She's gonna be joining Women on the Rises re-entry program because of her residential challenge and financial indigency. So I think $50, 50 hours of community service is more than sufficient.
Are you saying like you want a total of 50 hours?
Yes,
That's fine, Your Honor.
thank you.
okay, so no fine. Instead of 40 hours of community service, it'll be 50 hours of community service. And give me the rest of your recommendation, please, Ms. Desiano.
Yes, Your Honor. 12 months, served 30 days, credit for time served 15 days from September 12th, 2024 to today, balance probated, stay away from the CVS at 895 Holcomb Bridge Road, an anti-theft course, and 50 hours of community service. And we'd ask the defense to stipulate to venue, factual basis, and ID for purposes of the plea.
Yes, we do.
And she agrees to the 50 hours of community service. Is that right, Ms. Lewis?
Yes.
Okay. Anything further before I take the plea, Ms. Kim?
No, nothing further from defense, Your Honor.
Ms. Lewis, you've been charged in case 24 CR 006466F with theft by shoplifting. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
You can place your hand down. With the charge that I read, it's my understanding that you wish to plead guilty to that charge. Is that right?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated, Ms. Lewis. When you complete the terms of the probation, I'll have it go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation and not have to pay those fees, okay?
Thank you, sir.
All right, good luck to you, Ms. Lewis.
Thank you.
Who do we have next?
We could go to position number 25, Mr. Norris.
Okay.
Oh. Number.
Yes, what are we doing with Mr. Norris this morning?
I'm
Good
sorry,
morning.
I believe Kim has to speak with him. We can change and go to position number 26, Mr. Ragland, Mr. Ragland.
Yes,
Okay,
Excellent.
and this is going to be a plea this morning?
yes, Your Honor.
Okay, good morning, Mr. Ragland. Can you raise your, good morning, sir. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
So, yes, sir.
Okay, thank you, sir. You place your hand down. Ms. Desiano?
Your Honor, state's recommending 12 months served 76 days, credit for time served 38 days. That's from August 20th, 2024 to today. Balance suspended. No further contact with Carlton Turner. Stay away from 711 Lee Street Southwest, Unit 601, and restitution will remain open for 30 days. We'd ask the defense to stipulate to venue factual basis and ID for purposes of the plea.
What is the restitution for?
He busted out the victim's window, and we were just it's unclear if the damage, how much the damage is. We have been in touch with him on September 13th, Your Honor. I believe that's when he was on SEA. And all the victim said at that time was that he wanted no contact and to stay away. So we would just like to keep restitution open for 30 days in case there is some restitution that needs to be paid. He can provide receipts for that, and we can schedule a hearing at a later time.
You want to personally?
I don't understand how we're going to monitor that if he's not on probation.
Exactly.
And
Okay, well, could we do probate it then until the 30 days and then it can suspend it after that?
We would like to object to actually having that restitution open then, because we got to have a invoice. We have to make sure that that was not overpriced or a fake invoice. I really think that it should be just stricken out.
Well,
Okay.
Your Honor, it sounds like it's a non-negotiated plea then. I can give you the facts and we can go from there and Your Honor can decide.
Okay, well, what are the facts?
Your Honor, this is a case that happened. The suspect, the defendant, took a light fixture and busted out the victim's bedroom window with it during an altercation. The victim and the defendant have apparently known each other for 11 years, and he was identified by the victim. The incident location is 717 Lee Street, Unit 601. And according to the victim, he states that he and the defendant were friends. They don't live together. He stated the incident location is his residence. The defendant was over at his residence when he asked the defendant to leave. The defendant refused and then busted out his window. He states that this is not the first time the defendant has busted out his window. He stated that the month before this incident, the defendant came to his residence and refused to leave and pulled a gun on him. And because of all of these incidents, he wants no contact and for the defendant to stay away. So the state is recommending 12 months served 76 days, credit for time served 38 days, balance suspended or probated, however we need to do it, so that we could leave restitution open for 30 days so that the victim has an opportunity to provide a receipt for the damage that was done to his windows. The defendant could pay for that potentially.
Okay, Ms. Kim?
Your Honor, we would like to object to restitution open for 30 days. He's got other case dismissed, and he does have a financial challenge. He does not have any employment as of now. There's no way he's going to be able to pay for the probation fee and also restitution. And he served already for 38 days, Your Honor. That's a lot of times for criminal trespass and property damage, Your Honor.
Okay. Mr. Ragland, it's my understanding that in case 24 CR 006461F, you wish to plead guilty to criminal trespass and damage to property. Is that correct?
Sir, okay, I'll.
You're under the influence of any drugs or alcohol this morning?
No, sir, no, all right.
Represented by counsel, are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
Oh, sir.
I'll accept your plea, Mr. Ragland. The court sentence will be 12 months to serve 76 days, credit for time served 38 days, balance suspended, no further contact with Mr. Turner, stay away from the Lee Street address. And if Mr. Turner would like to proceed in a civil matter for restitution, that will be his choice. I'm not gonna order any restitution at this time, given that I believe there's been adequate time to get it from the victim, and he can proceed civilly if he chooses to. Good luck to you, Mr. Ragland.
Thank you. Have a blessed day, sir.
You can say that, Gerald.
Hold on. Position 24, Mosby.
And what are we gonna do, Ms. Mosby, today?
Your Honor, that's my case. I tried to speak with him yesterday, but he did not appear at the window, so I haven't had a chance to speak with him yet.
It's a she, it's a she.
Oh,
Okay, so we'll give you the opportunity to speak with Ms. Mosby.
that's
And
why
Mr.
I
White,
couldn't.
did you get my email
What
about the
number can
restitution
we-
on this one?
I did.
Okay, cool.
What
That's
number
why I was-
can we call you at, Mr. White?
It's in the chat.
Okay. I'm going to the next one.
That's the courtroom too, though. I'll send it to you.
Next, we can do position number 32, Thomas.
I have it. This is a conflict attorney case. Whose case is this? Do we have a conflict for
The announcement listed Daniel Pozo as the attorney.
So, Mr. Thomas, have you spoken with anyone in regards to your case? Do you have an
No, sir.
Okay.
He is actually, Robert Thomas was found to be a conflict because after another case was moving forward, his attorney is, last name is Pozo, P-O-Z as a zebra and O, but we were not able to contact him to appear today. So we would like to ask for a reset for next Tuesday, since there's another case that is holding him here in the jail.
Ms. Kim, I do not see an entry of appearance on that attorney. This was a case that originated with Orca, and then it was transferred back to the division judge. So at this point, can you give me the name of that attorney again, or you can
Yes,
send it to me?
I'll do that.
Or
I
send
have
it-
a
send it
contact
to me.
information. I can forward that to you, Mr.
Yes,
Lewis.
please
Yes.
do, so we can try to
And
get in
also
touch with
email
the
from
attorney
other
before we
attorneys.
set it again. Yeah, you can forward that to my email so we can try to get in touch
Absolutely.
with the attorney to verify.
Sure.
But what you're telling me, Ms. Kim, is that he's being held on another case that's going to keep him in at least till next Tuesday. Is
Yes,
that right?
or even, yes, definitely.
So maybe we can work this out by next Tuesday. So let's reset Mr. Thomas's case till next Tuesday, which will be
Judge, that would be, the 1st of October.
October 1st.
Mhm.
Okay, Mr. Thomas, we'll see you back on Tuesday. We'll see if we can get in touch with your attorney.
Next, we can do position number 1, Mr. Bardell.
And this is going to be a negotiated plea, is that right?
That's correct, Judge.
Okay. Good morning, Mr. Bardells. Can you raise your right hand for me, please? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? And you can place your hand down. Thank you, sir. Ms. Desiano?
Your Honor, the state's recommendation is 12 months served 60 days, credit for time served 14 days from September 13th, 2024 to today, balance probated, a $250 fine, and no driving. We'd ask the defense to stipulate to venue, factual basis, and ID for purposes of the plea.
We stipulate, Judge, we just ask the probation terminate upon payment of his fine.
Any objection?
That's fine, Your Honor.
Okay, Mr. Bardells, it's my understanding that in case 24 CR 006467E, you wish to plead guilty to promotional organization of an exhibition of illegal drag racing. Is that correct?
I do, sir.
Are you under the influence of any drugs or alcohol this morning? You've been represented by counsel. Are you satisfied with his representation?
Sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury? Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Bardells. When you complete the terms of the probation, it'll go to it'll terminate. But just know that the no driving is gonna be for 12 months, so you can't be driving within that time.
Okay.
All right, good luck to you, sir.
Thank you, sir.
Thank you, Your Honor.
You're welcome.
We can go to position number 14, Mr. Cunningham. Cunningham.
Thank you.
Also a negotiated plea.
No.
That's correct, Judge.
Hey, hold on.
Cunningham.
Hold on, Kim.
Good morning, Mr. Cunningham. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Yeah, speak up for me, Mr. Cunningham.
Yes.
Okay, you can place your hand down. Thank you, sir. Ms. Desiano?
Your Honor, state's recommending 12 months served 36 days, credit for time served 18 days from September 9th, 2024 to today. Balance suspended, stay away from Emory University Hospital at 550 Peachtree Street unless receiving medical treatment. We'd ask the defense to stipulate to venue, factual basis, and ID for purposes of the plea.
We stipulate, Judge. Nothing further.
Okay. Mr. Cunningham, it's my understanding that in case 24 CR 006370D, you plead guilty to criminal trespass. Is that correct?
Cunningham, please answer your question.
Did you hear my question, Mr. Cunningham? Mr. Cunningham, can you hear me? Okay, and my question is that do you want to plead guilty to this criminal trespass?
No.
Okay, so I'm asking you, it's my understanding that you were going to plead guilty to criminal trespass. Okay, do you still desire to plead guilty to this criminal trespass charge?
Yes.
Okay.
I believe he said guilty, Judge.
Okay. Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by Attorney White here. Are you happy with what he's done for you?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right? Do you understand that? Okay, so you don't want a jury trial, do you? And you understand that you have a right to a jury trial if you want one, right?
Yes.
But you don't want one, is that correct?
Yes.
Okay. Has anybody forced you to plead guilty to this charge, Mr. Cunningham?
No.
Okay. I'll accept the plea as negotiated, Mr. Cunningham. Good luck to you, sir.
Thank you, Your Honor.
This is gonna be position number 4 on the add-on calendar, Hollins.
Okay. What are we doing with Ms. Hollins this morning?
Your Honor, this is Deputy Rhodes' case. He should be here soon. However, I don't have any information of whether or not the DA's office has accepted this case or not. It's my understanding that on Tuesday he was going to follow up. I can text him real quick and ask.
He's on the line, Ms. Desiano.
Oh, here we go.
Mr. Rhodes, good morning.
Morning. How are you doing?
I'm doing well. Hope you're as well. Let's see, this was on the calendar on Tuesday, and you all were gonna speak, I believe you and council.
That is correct, Your Honor. I believe that we did make the query to the DA's office as it relates to Quinetta Hollins' case. And I believe that we did get a response back. Give me one moment, Your Honor. Yes, we did get a response back from the DA's office on that one. They have declined to accept that particular case.
Okay, do you have a recommendation? Is this your case? Whose case is this? Who's representing Ms. Hollins?
Your Honor, what was the case number? I
Um,
apologize. I was on the phone. and I couldn't-
Position 4 on the add-on calendar. I'm not sure if this is Ms. Mahfoud's case or not. I can't remember from Tuesday.
No, Your Honor, my case is LeVar Reed.
Oh, okay, thank you.
We don't represent any of add-on calendar except
Well, somebody must have represented her
what's
on
the
Tuesday.
last name again, Your Honor?
McLeod. Excuse me, I'm sorry.
Oh, you're represented by Ms. McLeod?
Yes, yes, sir.
Okay, all right, so we'll wait. So if you can do this, do we expect Ms. McLeod to be out? Oh, there she is.
She's right there, Judge.
Ms. McLeod, are you with us?
Good morning, Your Honor. I am.
Yes, good morning, Ms. McLeod. Apparently, the DA is not accepting the Hollins case. As such, Mr. Rhodes, have you all prepared a offer in the matter?
I have not, but I will get an offer over to Ms. McLeod during this calendar. So I'll get one over to her.
Okay, so we'll get you an offer and then we'll have you discuss that with Ms. Hollins. Okay, Ms. McLeod?
Yes, Your Honor. Thank you.
Okay, so we'll be back with you, Ms. Hollins, and I will allow Ms. McLeod to speak with you prior to you speaking back with me, okay?
Okay, thank you, sir.
You're welcome.
We can move on to position number 17, Mr. Griffin. Griffin, that way, wrong way, wrong way, wrong way. More, you gotta excuse the man.
Okay. Has anyone spoken with Mr. Griffin?
I have, Your Honor. He is now negotiated plea.
Okay. Good morning, Mr. Griffin. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. What's not negotiated about it, Mr. White?
I'm sorry, I said negotiated.
Oh, I'm sorry. I thought you said non-negotiated.
I think I said now negotiated. So
Oh, okay. All right. Thank you. I apologize.
no worries.
Let's see. Who's presenting for the state?
Your Honor, position number 17 is my case.
Okay, whenever you're ready, Mr. Rhodes.
Yes, Your Honor, as it relates to position number 17, Mr. Griffin, the state's recommendation is 12 months to serve 32 days. It's our understanding that he's already served 16 days and that the balance to be suspended. So in essence, it's 12 months credit for time served and balance suspended. The only ask that we have is that during this period of suspension, that he stay away from Emory University Hospital, located at 550 Peachtree Street, Atlanta, unless for medical treatment. I do believe that's the Michigan campus, Your Honor.
Anything further, Mr. White?
Nothing further, Judge.
Mr. Griffin, it's my understanding that in case 24 CR 006435C, you wish to plead guilty to criminal trespass. Is that correct?
Sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
Do you understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Griffin. Good luck to you, sir.
Thank you, Judge.
Who do we have next?
This is gonna be on the add-on calendar, position 3, Mr. Reed, LeVar.
Good morning, Your Honor. I don't know why my
Good.
video is not turning back on. Oh, here it is. Good morning, Your Honor. Teresa Mafood here with the Law Offices of Carlton R. Matthews on LeVar Reed. We'd like to do a pre-trial conference this morning, and Attorney Matthews will actually be able to handle that.
Okay, well, your client is with me right now, so is he available now?
Yes, Your Honor.
Okay, and have you all had I'm not really sure why I can't remember why we continued this until today. Can somebody remind me, please?
Yes,
Your Honor. This is a situation where we've requested an upgrade with the DA's office. We left this on Tuesday because this case has been reset for like 3 weeks at this point, and it's because the allegation is that the defendant punched the victim repeatedly, like 10 times in the face, and her teeth were like put up into her skull, so she had to have surgery to have her teeth pulled back down. And so this case was initially reset for the first couple weeks because we were waiting for the documentation from the victim in order to request a transfer to the DA's office. And as of Tuesday, DC Rhodes and I were not sure if DC Deputy Falk had requested a transfer yet. So after court on Tuesday, we did request a transfer because we did receive documentation from the victim. And that request was made Tuesday. We followed up Wednesday. We actually spoke with the DA's office yesterday. And long story short, they're interested in taking the case. However, they've requested the medical documents that we have provided to them are the medical bills showing the surgeries and all of the ER visit and the ambulance ride and all of that. However, the DA's office is asking for x-rays and documents that show pictures of the actual injury. And so at this point, we would request a reset. I know this case has been reset several times. However, realistically, we need about a month reset in order to get the rest of these documents. And the biggest issue and why we're requesting an upgrade, Your Honor, is because the restitution is very high. The oral surgery was $10,000. The ER visit was $1,000. The ambulance ride was about $2,000. So this is not just a case that we can resolve very quickly on SAP. You know, of course, the state always likes to expeditiously resolve cases, but it doesn't mean that every case can be resolved quickly. And just with the extent of the injuries here and the amount of restitution, there's only so much that state court can do as far as sentencing him. And that's why we're pushing for an upgrade. And I understand the defense is going to vehemently object to that, and they want a pretrial for whatever reason, which we could do that. But that's the reason why this case was reset. And we are again asking for another reset, but this time for at least 30 days, Your Honor, so we can get the rest of these documents, because what's been provided so far is part of it, but it's not all of it. And of course, as the court knows, getting medical documents from the hospital isn't something that happens instantaneously.
Good morning. We don't object to a signature bond on these particular charges.
Yes.
Oh, okay. Well, y'all should have started with that.
Well, Your Honor, good morning, Your Honor. Can you hear me, Judge?
So.
Can you hear me, Your Honor?
Yes, I can hear you. Is this Mr. Matthews?
Yes, Your Honor. Good morning to this honorable court. Carrington Matthews on behalf of our client, Mr. LeVar Reed. Your Honor, I'd like to begin with the signature bond is not going to matter in this case. Why? Because Mr. LeVar Reed, he signed a waiver to have his parole revoked. So any day now, Mr. Reed could be transported to the Department of Corrections to finish out a sentence with the state of Georgia. So that's one issue. The other issue is that the matter has been reset numerous times. We've made consistent and diligent efforts to communicate with the prosecution regarding this case. I think Attorney Teresa Mafood reached out to Attorney Shelley Falk, Prosecutor Falk, on a number of occasions via email. She has been unsuccessful in reaching out to and talking with that particular person. And secondly, Your Honor, I did send an extensive email correspondence to ASG Taylor Daciano on yesterday. I did not get a reply to that email. I know she's probably busy and just wasn't able to get to it, I understand, or she just wanted to make an announcement before this court today. Your Honor, what concerns me is that this particular case is the injury, the alleged injury that's driving the prosecutor to say, hey, I want this case to go to the district attorney's office. However, Your Honor, what the state is not telling this honorable court is that in the warrant, it is inconsistent with the police report itself. There was a melee that took place prior to my client allegedly even getting involved in this alleged incident. And the officer, Your Honor, indicated to the alleged victim that he did not believe she was being completely forthright and straightforward with him during the course of the investigation. There's been no identification. I want to repeat this. There's been no identification made by the alleged victim upon through the state of Georgia that Mr. LeVar Reed was actually involved in terms of putting this injury on her. However, Your Honor, as this court knows, there's always an opportunity to have a conversation and determine whether or not a case can be resolved between the parties, given the issues, the proof issues that are in the case. There's been no identification, no photographic lineup, no viewing of any social media or any driver's license photo by the alleged victim. The alleged victim was not cooperative at the scene with the officer, and that needs to be put upon the court so the court can know the full extent and context of this particular case. That's why I wanted to have a pretrial with the prosecution to say, hey, listen, if we can resolve this matter, restitution, just like in state court, just like in the district attorney's office and in the superior court, can be handled in a state court setting as well. And we all know that if we can resolve a matter, we can always have a separate hearing on the issue of restitution and damages and things of that nature. So I don't believe that should be a roadblock to a resolution. They have not spoken to their alleged victim. Their alleged victim has not been cooperative. So those are the reasons, Your Honor, that I think that a pretrial should be had. But I can't force a state to resolve the case with me today, and I understand that. I just wanted the court to know the full context of the picture from our perspective.
In Your Honor, point of clarity, we have had contact with the victim in this case. We do have contact with the victim. She's been very cooperative. As a matter of fact, we provided her information to the district attorney's office as well. And I will say that part of the problem with resolving this case in state court is that we have one charge, which is 12 months, which he would potentially be serving that 12 months upon being revoked and sent to the Department of Corrections. And there's no way to ensure on our end that the victim would fully be restored and get the restitution that's needed. But our rationale and reasoning for transferring is based on the extent of the injury and the conduct of the defendant as it relates to this particular victim having to have oral surgery, and endodontists have to get involved to actually pull her teeth back in place. We think this is beyond a mere misdemeanor, and that the contact made by the defendant to the victim was felonious. And so therefore, that's why we're doing our due diligence. The district attorney's office is doing theirs. But as indicated earlier, I do understand that Attorney Matthews believes that there are some issues for trial as it relates to identity, and those are issues for trial. The state is willing on this charge to agree to a signature bond, so he's not held on these charges.
So, Your Honor, we respect the prosecution's position, and we are thankful that the prosecution is willing to offer and extend out a signature bond in this case. So essentially, if Mr. Reed executes a signature bond today, then this particular matter will no longer be holding him. If he goes to, which he will go to the Department of Corrections, Your Honor, when he's released, this matter will not be holding him, and he'll be able to walk out of the system and deal with this case at a later date. We were hoping that we could resolve this case today. It appears that that's not going to happen. And just in context, Your Honor, our position is that the alleged victim and another young lady were engaged in a broil. They were fighting before my client ever allegedly attempted to break up any altercation between these folks. So Mr. LeVar Reed maintains that he did not exact upon this lady any injuries that she is alleged to have sustained on that particular evening. So that's our position, Your Honor. I think the court has heard us out. Thank you for giving us a platform this morning to address the court on this matter.
Okay, what is the current bond?
He's in no, I think he's in no bond status, right?
Not for this case. On this case, Your Honor, he has a $3,000 surety bond.
And I have that he has 2 charges of battery, is that correct?
Yes, that's correct.
And that $3,000 bond is broken down $1,500 per charge.
Let me confirm, Your Honor, before I.
What I'd like for you to do, Ms. Desiano, Mr. Carlton, I'm sorry, Mr. Matthews, it's normally if I'm modifying the bond, which I am, I normally have the defense counsel prepare that modification for the court. Are you in a position that you can do that this morning?
I can modify the bond. Basically, what I'm here in the court to say is, hey, provide the court with an order that converts a $3,000 bond into a signature bond with standard conditions of no contact with the alleged victim, stay away from the location, Your Honor.
Yes, that's correct. And I'm being told that it's a $3,000 surety bond on each charge that would make
Yes,
it
Your Honor.
that would make it a $6,000. That's your fine. $6,000 surety bond altogether. So we'll convert that to a $6,000 a sign-on bond. I'll have it go through the jail.
Can the state give us an assurance that when they send this case over to the district attorney's office, that they will put in their record that Mr. Reed has a $6,000 signature bond, and to not put a grand jury hold on Mr. LeVar Reed for any additional charges that they decide, if they decide to indict this case, that they decide to put upon Mr. Reed, that would hold him in continued custody when it's time for him to release, because that is a tactic that the district attorney's office consistently does when it comes to their getting these cases, and these folks have made bond. They then indict the case, they add charges, they put a warrant on the person person cannot get out.
You'll have to take that up with the district attorney's office. I don't know if these solicitors have any jurisdiction over what happens if and when this case is transferred to the district attorney's office. If it's transferred, then you make your argument before the appropriate district attorney at that time. But at this time, I'm going to convert the signature bond. Convert the surety bond to a signature bond. What were the conditions, Ms. Desiano? If you'll just list what's on there for me, please.
Your Honor, the only conditions that are on the bond are no further contact with the victim and no weapons, drugs, or alcohol. It's my understanding the incident location was a public place, so there's no stay away.
Okay. So are we clear on that, Mr. Matthews?
Yes, Your Honor. Thank you.
Okay. Anything further this morning?
Not for the defense, Your Honor. Not for Mr. Reed. I do have a question for the court. Can I get the warrant numbers, and can I get a destination where the order should be sent to?
Yes, it should be sent to Miss Katrina Lewis. Her
I just sent it to the email that's for Teresa. Did you look at the chat? You see the chat, sir?
Yes.
Yeah, send it to me. I appreciate that. Thank you.
All right. And the information, the warrant number and all that stuff?
It will just be the case number that's on the calendar, 24 CR 005871 F as in Frank.
005871 F as in Frank.
I could put it in the chat too.
Okay, great. Your Honor, thank you very kindly.
You're welcome. You have a good rest of your day.
You as well, sir. Thank you.
Thank you.
Next, we can go to position number 23, Mr. Rashad Moore.
You're also going to be a negotiated plea. Is that right, Mr. White?
That's correct, Judge.
Good morning, Mr. Moore. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, Mr. Moore. Tatiana?
Your Honor, state's recommending 12 months served 34 days, credit for time served 17 days. That's from September 10th, 2024 to today. Balance suspended and a stay away from Atlanta International School at 2890 Fulton Road. We'd ask the defense to stipulate to venue factual basis NID. Thanks.
We stipulate nothing further, Judge.
Mr. Moore, it's my understanding in case 24 CR 0064004A, you wish to plead guilty to criminal trespass, is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up that right?
Yes, sir.
Has anyone forced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. Good luck to you, Mr. Moore.
Thank you, man.
Thank you, Your Honor.
Welcome. Next.
Going back to position number 24, Mosby.
And this is a negotiated plea, Judge.
Okay. Yes, good morning. Again, Ms. Mosby, can you raise your right hand for me, please?
Good morning.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down, ma'am. Thank you. Ms. Desiano?
Your Honor, state's recommendation is 12 months served 34 days, credit for time served 17 days. That's from September 10th, 2024 to today. Balance probated, no further contact with Jercary Jackson. Stay away from 2949 Baker Ridge Drive Northwest. Your Honor, the restitution is actually $300. I've been in touch with Mr. White. We got the receipts. I believe your paper says $250, but it's $300. Restitution to the victim, and probation may terminate upon the payment of restitution. And we'd ask that it stipulate to thank you.
Mr. White?
We
Sounds
have-
like a question.
That's exactly what we discussed, Ms. Mosby. I'm not sure if you misunderstood what she was saying, but it's $300 in restitution and the probation will terminate once you pay that. Okay.
Yeah.
We have nothing further, Judge.
Okay. Ms. Mosby, it's my understanding that in case 24 CR 0064228G, you wish to plead guilty to criminal trespass and damage to property. Is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
I'm detoxing right now.
Say it again.
I'm detoxing right now.
So no.
Okay.
Correct?
So you're not under the influence of any drugs or alcohol right now as we speak. Is that right?
Correct. I already did.
You understand what you understand what you're doing this. Is that right?
Yes, but the money part, like, can be free.
I'm not understanding what she said, Mr. White, so I don't know if
I didn't catch that either.
Gotta speak up, talk loud.
I said like the $300, like it can be free, or I have to pay.
You have to pay. When we talked about this, your exact quote to me was that was easy.
Yeah, but you're right. But I don't feel like they deserve my money though.
Okay. Do you not want it?
Yeah, I accept it.
Okay.
All right, so there's gonna be $300 that you're gonna have to pay back or to pay. And then once you get it paid, you'll be done. You won't be on probation anymore. Okay? You understand that?
Yes, sir.
Okay, so let me finish up with the questions that I have for you. You've been represented by Mr. White. Are you happy with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anybody forced you to plead guilty?
No, sir.
Okay, I'll accept your plea as negotiated, Ms. Mosby. When you pay that $300, you're not going to be on probation anymore, okay? So the sooner you get it done, the sooner you won't be on probation or you've held this behind you, all right?
Thank you, Your Honor.
Good luck to you, Ms. Mosby.
Okay.
We can go to position number 25, Mr. Norris.
Yes, and what are we doing with Mr. Norris?
Yes, negotiated plea, Your Honor.
Okay. Good morning, again, Mr. Norris. Can you raise your right hand for me?
Sir. Yes, sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. Ms. Desiano?
Your Honor, state's recommending for count 1, the loitering, 12 months probation concurrent with count 2. Count 2, theft by taking, 12 months served, 38 days, credit for time served, 14 days from September 13th, 2024 to today. Balance probated. Stay away from the Marriott Marquis at 265 Peachtree Center Avenue and an anti-theft course. Count 3, the obstruction, 12 months probation concurrent with count 2 and a $300 fine. And count 4, the drug-related objects, time served, 28 days, credit for time served, 14 days. We'd ask the defense to stipulate to venue, factual basis, and ID for purposes of the plea.
Yes, we do.
Anything further, Ms. Kim?
Nothing further from defense, Your Honor.
Okay. Mr. Norris, it's my understanding that in case 24 CR 006476E, you wish to plead guilty to loitering and prowling, theft by taking, willful obstruction of law enforcement officers, and possession and use of drug-related objects. Is that correct?
Sir, yes, sir.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with her representation?
Sir, yes, sir.
You understand that you have a right to a trial by jury on this charge, these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Sir, yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Mr. Norris. When you complete the anti-theft course and pay the $300, the probation will go to a non-reporting status. So the sooner you get that done, the sooner you won't be on reporting probation and have to pay those fees, okay?
Sir, thank you, sir.
All right. Good luck to you, Mr. Norris.
Thank you, sir. Have a blessed day. Come on.
You too.
I can't believe you or not. You messing up my name.
Okay.
Going back to the add-on calendar, Judge, position number 4, Hollins.
Yes, Ms. McLeod, what are we doing with Ms. Hollins' case today?
Your Honor, we would like to seek a signature bond for Ms. Hollins.
Okay, so you're gonna plead not guilty, is that my understanding?
That is correct, Your Honor. And I will be filing a waiver for arraignment for her.
Okay.
Your Honor, my client.
Let me hear from, do we have anybody from pretrial on? Yes, Ms. Washington, since you're seeking a bond modification, let me find out what her history is, then I'll come back to you, Ms. McLeod, okay?
Yes, Your
Yes,
Honor.
Your Honor.
And this is Ms. Hollins on the add-on, correct?
Yes, that's correct. And while we're waiting for the history then, Mr. Rhodes, can you give me the facts of the case and what the current bond is?
Yes, Your Honor. As it relates to the facts of this case, Your Honor, probable cause was found that on August 18th of 2024, officers were dispatched to a fight call and disorderly conduct call. Officers approached the scene and males pointed towards a victim and an offender as the two individuals involved in this melee. They observed the male subject who was seen with multiple lacerations to his head and bleeding from those lacerations. The female subject was observed with minor scratches. They were attempting to assess the situation. The female got into an additional dispute with a different male as he began walking away from her. She berated the male, attempting to initiate an altercation with him as well. The male, however, walked away and left the scene. The female then attempted to flee the scene, getting into the passenger seat of another female's vehicle. Officers informed the female driver that no one was to leave the scene as they were assessing the situations. At some point, Officer Young finally spoke with all of the witnesses on scene, who indicated that the defendant in this case sorry about that, Your Honor, one moment, that the defendant in this case confronted the victim by striking the male subject as he was reading a newspaper. They then got into a verbal dispute. After the verbal dispute, the female then subject, he struck the male several times in his head area. Officer Young placed the female in the back of his patrol car, which was searched for contraband, weapons, and tools of escape, and none were found. And I do need to state that prior to him placing her into the patrol car, she did flee from officers, and they had to use a tackling maneuver to get her to the ground, Your Honor. Officer Young then transported the female to College Park jail, providing the beginning and end of his mileage. Upon speaking with the owner of a nearby store, officers were able to get camera footage of the incident, and while watching the footage of the altercation, they were able to confirm what the civilians told them about what happened during this incident. They observed on camera the female throw an orange traffic cone at the male subject, stand in the middle of traffic, walk to the MARTA bus stop and throwing rocks at the male subject, and lastly proceed to strike the male subject several times, causing him to fall to the ground. Afterwards, the female made multiple more strikes to the male's head area. Officer Lee and other officers then began investigating to discover the victim's name, and they found out the victim's name was a Mr. Andre Docks. Officer Lee and other officers was able to find Mr. Docks and found out that he was stabbed multiple times by the female, who is the defendant in this case. After the investigations, officers then relocated to College Park Jail to search the female for contraband, and they found none. And so that's the basis for the actual charges in this particular case, Your Honor.
What's the current bond?
One moment, Your Honor.
Okay. Do you have the history while he's looking for that for me, Ms. Washington?
Yes, Your Honor. There are 30 arrest cycles, 2009 misdemeanor conviction for criminal trespass, an FTA in 2011, 2012 misdemeanor conviction for possession of marijuana less than an ounce and battery, and that was in Cobb County. 2012 misdemeanor conviction for a simple battery in Cobb County. 2013 felony conviction for theft by receiving stolen property out of Cobb County. There's a 2014 misdemeanor conviction for violating a family violence order. 2015 misdemeanor conviction for giving a false name. 2018 felony conviction for ID theft. 2019 misdemeanor conviction for battery, and also the defendant pled NOLO to simple battery in Clayton County. A 2024 misdemeanor conviction for 2 counts of battery, and that was out of Cherokee County, but the arrest was made in 2020. In 2024, I'm sorry. In 2024, there was a felony conviction for aggravated assault, terroristic threat, and that was out of Fulton County. And it appears that the defendant is currently on probation for that. There is an FTA listing from 2024. Nothing further, Your Honor.
And Your Honor, as it relates to the bond, I was able to find that the current bond is a $2,000 surety bond. Your Honor, at this time, the state would ask that you amend the bond to a $5,000 cash-only bond, given the defendant's history. Most of it is extremely violent in nature. She is a career criminal as far as I'm concerned. So any modification to bond should be an increase, and she should be made to pay a cash bond, Your Honor.
And what's the breakdown of the bond, Mr. Rhodes? Do you know?
Yes, Your Honor. Currently, she has a $1,000 bond on battery, $500 bond on the willful obstruction that was described, and another $500 bond on a simple assault. And what the state would be asking is for $2,000, $2,000, and $1,000 cash bond.
Who gave her that bond?
One moment, Your Honor.
That's fine, Mr. Rhodes. It doesn't matter. Thank you. Ms. McLeod?
Yes, Your Honor, my client only had a $2,000 bond, a good bond, and she was unable to pay it. She has been in jail for the past 3 weeks or more, and her version of what happened is completely different from the state's version. My client tells me that she was first attacked by this man. This is not someone that she's in a relationship with or anything. She was attacked by this person. She was merely defending herself. Just because he may have gotten the worst of the altercation between them doesn't mean that he was not the initial aggressor, which is what my client maintains, Your Honor. She is the mother of a 4-year-old who is out there being taken care of by her sister. She has responsibilities to pay rent and all that sort of thing. And it's just been a huge hardship for her to be locked up like this, Your Honor. She doesn't have money to pay bond. If she could not pay a $2,000 good bond, of course, she's not going to be able to pay a $5,000 good bond. The state tried to get this case upgraded to a felony. Obviously, the DA's office looked at whatever footage or whatever evidence they had and determined that this was still a misdemeanor. So even though those kinds of allegations were made, my client tells me she was trying to get help because this man kept following her and kept beating on her. And she just tried to defend herself. So it's still a misdemeanor, Your Honor, and I am asking for signature bond for my client. Otherwise, she's just going to sit in jail until this case is resolved. Nothing further, Your Honor.
Okay. I apparently issued this bond at the SCA calendar. I don't see that anything has changed since I issued the bond. As such, I'm not going to modify it. Yes, good luck to you, ma'am.
Thank you, Your Honor.
Who do we have next?
Your Honor, I also have on the calendar the issue with Mr. Quantavious Green.
Add on position number 1, Mr. Green.
Okay. Perfect timing, Ms. McLeod. What are we doing with Mr. Green today?
The state was supposed to confirm about his time, Your Honor. Based on our calculations, Mr. Green should be released tomorrow. He was on Tuesday, as the court will recall.
I do. Were you all able to resolve this, Mr. Rhodes?
Your Honor, I think when we were last on, the state's position was that we do believe that the intent was for him to receive time served. So if we could submit a joint, I don't know if we're going to have to do an amendment of the previous sentence, but if we could submit something jointly, Ms. McLeod, to Judge Morrow as it relates to asking the court to amend the sentence just to show that our intent was for it to actually be a time served. We could work on that today and get that over to Judge Morrow today so that we can ensure that he gets out.
Okay,
tomorrow.
can you do that, Ms. McLeod?
Your Honor, I could do it, but it wouldn't be until late afternoon because I'm actually at the airport in Milwaukee right now. I'm about to board a flight, so I don't have access.
So I think that Mr. Jordan sent you all something about
He did.
About this matter. Appreciate that, Mr. Jordan. Thank you. So if Mr. Rhodes, I guess if you can prepare something so that maybe by the time Ms. McLeod lands, that she will be able to review it and you all will be able to get it to me by the end of the day.
Absolutely, Your Honor. I believe it'll be a motion to amend sentence just to make sure that he receives time served.
Yes, and as soon as I'm able to, I will look at it. I don't think I'm going to get to Atlanta until about 1. Okay.
All right, so Mr. Green, we'll do that for you today, and you should be, it's my understanding, get it out directly. All right, good luck
Thank
to
you,
you.
Your Honor. And that concludes my business before the court today. May I be excused?
Yes, be safe on your flight, Ms. McLeod.
Thank you. Thank you, Your Honor.
Who do we have next?
You can go to jail court's iPhone.
Okay.
We have position number 18, Mr. Johnson.
All right.
And Your Honor, that is a
Yes.
conflict case that was not previously, I do not believe was previously taken care of as a conflict case. But I made the announcement yesterday that
Oh, okay. Have we gotten Mr. Johnson an attorney?
No, sir, because this is the first time hearing about it.
Okay.
Should have kept Ms. McLeod on the line.
Let's see.
we represent the co-defendant in this case in a felony. Judge, that's why
Okay.
the conflict.
Can we see if we can raise somebody today? Ms. Lewis?
We'll try. I got Mr. Jordan in the office with us, just us today, so we'll try to call around and see if anybody can get on the line.
Okay, all right. So Mr. Johnson, we're gonna try to get someone to represent you. If we can't, the case will unfortunately have to be postponed until next Tuesday, October 1st, but I'm gonna see if we can get somebody on the line to represent you today, okay? So we'll be back with him, hopefully.
Thank you.
Hold on.
Next, we can go to position number 19, Mr. Johnson.
And FYI, Judge, this charge is not holding him in jail.
Oh, okay, so this charge isn't holding Mr. Johnson, Mr. Position 18?
That is correct, Judge. She's in.
Okay, all right, so we're just gonna go recess until October 1st, which is next Tuesday. Okay, all right, so we'll see you back next Tuesday, Mr. Johnson. I'm sorry, tell me again where we are.
19, Mr. Johnson.
19. Okay, and what are we doing with Mr.
That's a negotiated plea, Judge. I was
Okay,
going to speak with him this morning.
and this is Miss Johnson, is that right? Is it Nakia Johnson?
It is, Mr.
Mr. Okay. Good morning, Mr. Johnson. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
All right, you can place your hand down. Thank you, sir. Ms. Desiano?
Your Honor, we may have the same issue we had with the first case we did, because I had requested that the restitution be open for 30 days and balance suspended. So the state's recommending for count 1, time served 20 days, credit for time served 10 days. Count 2, the criminal trespass and damage to property, 12 months served 20 days, credit for time served 10 days. No further contact with the victim, Jacqueline Richardson, stay away from her residence, 422 Village Lane, Union City. And we'd like restitution to be open for 30 days.
And what is the restitution for?
It's, there was damage to the victim's screens. The defendant was trespassing on her property and damaging her screens. And he came on her property several times, and we've been in touch with her. So she's cooperating. We just don't have the any documentation as far as the repairs to the screens at this time.
Okay, Mr. White?
Judge, we're okay with leaving it open for 30 days.
Which means that she is gonna have to be on probation during that time so that we have some way of monitoring her and getting the restitution paid.
Well, can we just schedule a restitution hearing in 30 days?
That's fine, Your Honor.
No, they're gonna be up to probation. Once the case is closed with us on our end, we don't deal with it no more.
Okay, well, we're not agreeing to probation, Judge, because that wasn't the offer that I relayed to him.
Yes, Your Honor, and we've done pleas before where they've been suspended balance and we kept the restitution open. And then if they don't provide receipts, it just stays the way it is. We've done several cases like that before in the past. So this is the first I'm hearing that we couldn't do that.
Well, I guess different judges do it differently. I don't like to have restitution remain open and then plead to something because it could come back and then she could say these screens are worth $10,000. So I don't want her pleading him, I'm sorry, Mr. Johnson pleading to something where he doesn't know exactly what the issue is gonna be. Some other judges may do it differently, but I'm not down for that. Okay? So, given the nature of what's going on, I'm gonna have that just go to be a civil matter. And if she wants to pursue that in civil court, she can at that point in time. I'm not gonna have this man be on probation and not know down the road what the actual money damage is going to be. Okay,
Understood.
Mr. White?
Agreed, Judge.
All right, nothing further, Mr. Johnson. It's my understanding that in case 24 CR 006557G, you wish to plead guilty to 2 counts of criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anybody forced or coerced you to plead guilty?
No, sir.
I'll accept your plea, Mr. Johnson. The court sentence for the count 1 criminal trespass is 12 months to serve, 20 days, credit for time served, 10 days, balance suspended. And for the second criminal trespass, 12 months to serve, 20 days, credit for time served, 10 days, balance suspended, no further contact with Jacqueline Richardson, and stay away from the Village Lane, that Village Lane address in Union City. Good luck to you, Mr. Johnson.
Thank you, Your Honor.
Who do we have next?
Position number 33, Townsend.
Your Honor, this is a negotiated plea.
Okay, thank you, Ms. Kim. Good morning, Ms. Townsend. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes,
Okay,
sir.
you can place your hand down. Thank you, ma'am. Yes, Ms. Desiano.
State's recommending, Your Honor, for count 1, 12 months served, 32 days, credit for time served, 16 days from September 11th, 2024 to today. Balance probated, no further contact with Kutonia Strozier. Stay away from Marta Buses, 8 weeks of anger management and no firearms. And for count 2, Your Honor, will merge with count 1. We'd ask the defense to stipulate to venue factual basis and ID for purposes of the plea.
Yes, we
So
do.
she can go to, just so I'm clear, she can take the train, she just can't take the bus.
That's correct.
Okay, all right. And she understand that, Ms. Kim?
Yes.
Okay. Anything further, Ms. Kim?
Nothing further from defense, Your Honor.
All right. Ms. Townsend, it's my understanding that in case 24 CR 006453C, you wish to plead guilty to simple battery in a public transit vehicle or station. Is that right?
Right.
Are you under the influence of any drugs or alcohol this morning?
Yes, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, ma'am. Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you've given up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Ms. Townsend, let's see, when you complete the 8 weeks of anger management, I'll have it go to a non-reporting status. So the sooner you get that done, the sooner you won't be on reporting probation, okay?
Okay.
All right, good luck to you, ma'am.
All right, good.
Thank you, Your Honor.
Okay, who do we have next?
Excuse me, Your Honor.
Yes.
We're gonna I'm gonna log off and come back with Cornetta Jones and Miss Angela Morrow. So I have to go to the mental health court first, and I'll be
Okay.
back.
All right,
Thank you.
we'll wait for you. Anyone else that we can, okay, there we go. Who do we have on the iPhone?
We have positions 12 and 13, Mr. Craig.
And these are going to be negotiated, please?
Yes, Judge. We actually had these cases last week.
Oh, okay.
As it relates
Good
to-
morning. 1 second, Mr. Bose. Good morning, Mr. Crane. Can you raise your right hand for me, sir?
Yes, sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, sir. Yes, Mr. Rhodes.
Sorry about that, Judge.
No, you're fine.
As it relates to these particular cases, Your Honor, just wanted to ensure that Mr. White did receive the estimate for the restitution and that his client agrees to pay the restitution.
Did not receive any estimate for restitution.
I emailed it to you, I believe at george.white
And when,
this morning.
oh, well, yeah, no, I haven't seen anything that's come in since we started court.
Would you want to tell us what the restitution, how much it is and what it's for, Mr. Rhodes?
Just the amount of restitution, and Mr. Peter Utamwan, the victim, is online. The restitution that I received is for $475, which was damage done to the back screen and porch area of the residence. Not actually residence where he lives, but property that he actually owns, Mr. Utamwan owns. So he was able to provide the estimate of what it's going to cost to repair that damage.
Judge, I'm going to need to speak with Mr. Crane.
Okay, and so
Not doing any damage.
would you
when I
check your
talk-
email just to make sure that you have the documentation so that you can share it with him?
Right, and even if the documentation is proper, I'm pretty sure our stance will be that Mr. Crane did not actually do the damage. So I'll just need to speak with him. But
And so we may not have a negotiated plea, Your Honor.
well, we had a negotiated plea. This all came in after we negotiated the plea. So
The negotiated plea included restitution, and it was reset today for me to get proof of
an hour after court started. So I mean that doesn't.
No. When we sent you the offer, it listed restitution, Mr. White, and the restitution was uncertain, so it was reset today.
I need to speak
so
with
that
Mr. Crane.
Okay, so let's see. I think the easiest way to do that, Mr. White, is to place you into a breakout room. Is that fine with you?
That's fine with me, Judge. Thank you.
Okay, so jail court's iPhone, we're going to put you into a breakout room with Mr. White so that you all can discuss. Excuse me, and we'll come back. So let's see if we can take some of Ms. Kim's cases if possible in the meantime. And so if we can go ahead and place them into the breakout room. Who do we have at medical here?
Position number 2, Bishop.
Is that your client, Ms. Kim?
No, it is Mr. White's client.
Okay, so Mr. White's in a breakout room. Is there anyone
I
else that
have clients from position number 25 through the end, position number 35. Those are my clients, Your Honor.
Okay.
I can make an announcement.
Okay.
Erin Richardson, a waiver of arraignment,
Give us the number, please.
guilty, position 27.
And take your time with me, please. 7.
Yes,
So
not
Mr.
guilty.
Aaron Richardson's going to be a waiver.
Yes, Your Honor.
Don't need
Well,
Mr. Richardson today.
We were under the impression that she didn't need him in person, so that's why he didn't grab him yet. This is
Okay,
making sure.
we don't need him.
Okay,
Okay,
Yeah,
so
we
she's just
need-
making an announcement of who she doesn't need for us today.
Mr. Richardson, I would like to reschedule his case to next Tuesday because there was only one issue that if we understand what it is, maybe we can kind of come to a conclusion. So we would like to know if we can reset to next Tuesday.
Okay, that's October 1st. We'll reset position 27, Mr. Richardson, until October 1st.
Thank you. And 28 is waiver. And 29 is also waiver.
Okay,
30 and 31 waiver. and 34, 35 waiver.
Ms. Kim, your announcement for 30 and 31, I'm sorry, 34 and 35 was a reset, and you just said waiver. Is it a reset or a waiver?
Oh, actually, give me 1 second. Maybe I made a wrong note. Yeah, didn't. Let me double check. I think we have to reset. He didn't sign the waiver form. He said he wanted to consider, he was trying to get a facility lined up. So he needs some time to make some calls with his brother and sister. So we do have to reset. I
And which
apologize.
case was that, Ms. Kim?
34, 35, the last one, Your Honor, at the regular calendar.
Okay, and when would you like that reset until?
Tuesday is fine, Your Honor.
Well, can we go on to Thursday's calendar?
That's fine too. He has another case that is holding him,
Yeah.
so Thursday will not make a huge difference.
Yeah, please, because we're not be here tomorrow when Tuesday calendar still got to go out. So we're kind of like cramping right now, Judge, on that calendar.
Okay. That's fine.
So if we could just set the people to next Thursday, it'll be great.
Yes, next Thursday is fine.
Thank you.
Okay, Mr. White, are you back with me?
I am, Judge.
Okay, and what are we doing?
So, Mr. Crane has agreed to actually pay the restitution, even though we maintain that he's not the one that did the damage. We would like to enter this as an Alford plea. I mean, I know that it's not much, but it's something. And we'd ask that you waive all the fees. He is homeless. So anything that he earns will have to go to the restitution. And if he's paying fees, then that kind of defeats the purpose of the restitution. Be my argument.
Okay.
So we'd ask that you waive the fees and allows probation to terminate if he, gets it paid in the 12 months.
And which, Mr. Rhodes, which one of these charges will the 475 be on?
You're muted.
I'm sorry.
Say it again for me, Mr. Rhodes.
Position number 12, Your Honor.
Okay, all right. All right, so if it's agreeable with everybody, as far as position number 13, that will just be balance suspended and he'll be done with that charge. For the position number 12, it will be, and I'll take an alpha on both, I guess both of the charges. And it will be 475, balance probated, 475, terminate upon completion, and given his situation, Mr. White, I will waive the fees while he's on probation.
Thank you, Judge.
Okay, are we all in agreement with this?
Yes, Your Honor.
Yes, okay. Anything further before I take the pleas?
Nothing from defense.
All right. Can you hear me okay, Mr. Crane?
Yes, sir.
Okay. It's my understanding that in case 24 CR 003809C, you wish to plead guilty to criminal trespass, and in case 24 CR 006333C, you wish to plead guilty to criminal trespass. Is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges, and that by pleading to them, you've given up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead on?
No, sir.
I'll accept your offered plea as negotiated. Mr. Crane, let's see, as soon as you pay that $475, you're not gonna be on probation any longer, so I'm gonna have it terminate. And to help you out, I'm not gonna have you pay those fees. So, but the sooner you get it done, the sooner you'll get this behind you, okay?
Yes, sir.
All right, good luck to you, sir.
Thank you, Your Honor. Good luck, Mr. Crane.
Yes, sir. Thank you.
So who do we have next?
Your Honor, while we're waiting, I can make a few announcements.
Yes, good morning, Mr. Bartels.
Yeah, good morning, Judge. Yeah, while you're waiting, I can make a few announcements.
Okay, go ahead.
Okay, well, on the state all purpose, from number 3 through 7, Mr. Brown, after speaking with Mr. Brown, and I'm familiar with his history, the court may recognize him as well.
Yes.
I believe a reset next Thursday to the 11 a.m. calendar would be appropriate.
Okay, so for Mr. Rico Brown, it will be set to October 3rd.
Yes, sir. And he is also the add-on calendar number 2, Mr. Brammer. That is the same individual. So we would ask for that case to be reset as well.
Okay.
Okay. I also have one plea to enter.
What was that last case?
I'm sorry. Yeah, Mr. Rose, I just said number 3 through 7, and the add-on number 2, I'm asking for a reset next Thursday for the 11 a.m. calendar.
Thank you.
Okay, you're welcome. And also Ms. Angela Morrow, who is add-on number 5, she's on the state all purpose, but we're going to enter a plea when she's available.
Okay.
And also, just to let the court know, on the 11 a.m. calendar, there is one plea that we'll ask to enter, number 10, Ms. Jones. But I think Ms. Milton is going to get her later.
Okay. Very good. Thank you.
On that position number 10 on the competency counter, Mr. Bartel or Mr. Rowe, can y'all send me the recommendation on it?
I'll send it to you, Ms. Lewis.
Okay, thank you.
Okay, thanks.
Okay, are we ready at medical?
Is Mr. White out of the breakout?
Oh, yes, he's back. Yes.
Position number 2, Bishop.
Yes, I was unable to see Mr. Bishop. He didn't appear at the window yesterday, so I'll need a breakout.
Okay, so medical, we're gonna put you into a breakout with Mr. White so that the bishop can speak with him. Place him into a breakout. Mr. Bartels, are you with me?
Yes, Judge, I am.
We only have a few, I believe, that are left on the SAP calendar. Do you think that we'd be able to do the competency calendar a bit early?
I believe so, Judge, sure.
Okay, so while we're waiting, it doesn't appear that we have that many calendar. So who do we have here that,
I think either Ms. Desiano or Mr. Rhodes is doing the competency calendar.
You can put us both in there.
okay, so let's do that now. Let's go ahead and do the competency calendar.
Yeah,
While we're
there's
waiting.
nobody else in the courtroom, Judge, so we can do that.
Okay, very good. Thank you. So Ms. Lewis, are you with me?
Yes, I'm here, Judge.
Okay, so can you place courtroom 2, Ms. Desiano, Mr. Rose, Ms. Burgess, and myself into the well, here they are.
Position 2 is going to be a waiver.
I just sent the judge in the breakout room. Hold on a second. I'll bring him back.
Oh, no worries. We don't need him for that. It's just, we're just going to waive it. So don't do that on our account.
Yeah, as soon I put him in there, as soon as I saw you coming in here, so I closed it in there.
Okay, that's fine. Mr. White, is there an announcement? Mr. Bishop?
Yes, it's just going to be a waiver of arraignment and appearance. So we'll get that to you.
Okay, so
Not guilty. So.
through the division judge. Okay, so while we wait, let's just go ahead and do the competency calendar. You can just go ahead and place it into a breakout room.
Oh.
Okay, has anyone else joined us while we were away? Jail court typhoon. Position number 15. What are we doing with Mr. Corey today?
That is team. Oh yeah, Tom's here.
I believe the state is resetting that case. They're asking, I think they're looking to upgrade it.
Okay, and I've got something about a private attorney. Are you all representing Mr. Corey or somebody else representing him?
I believe we are, Judge. There was a name attached on the calendar, but he didn't know who that was. So,
Okay.
I'm assuming so.
Mr. Rose, have you all already requested a DA to transfer the case?
I have not seen where we requested it, but Your Honor, I will put that request in today. It's here that it would require voluntary.
So I'll reset it up till that next Thursday, October 3rd, if that's fine with everybody.
Yes, Your Honor. I'll put that request.
Thank you, Judge.
Okay, let's see. We're still waiting on Mr. Tony Johnson. Is that right? Well,
No, Judge, Mr. Johnson is a waiver of arraignment, so he's not needed.
Johnson is that?
20 and 21.
Tony, still. Yeah, it's correct, Judge.
Okay.
So he's a waiver of arraignment? I mean,
Yeah.
waiver for jury. He's already set for a jury trial counter from Judge Taylor already, position number 20. We already got a date for November.
So does that take care of everybody except for the competency calendar position?
And I think Mr. Bartel said there was another plea.
Your Honor, we have
An add-on.
position 10 on the competency calendar is a plea, and then we also have Miss Angela Morrow for a plea. I believe she's the last position on the add-on.
Yeah.
And then we also have two cases on the DB bench warrant calendar. One was a reset from Tuesday, and then there's another one.
Right, and it's like right at 11 is Leonie Farmer with us?
Yes.
Oh, is this you, Miss Farmer, under the Zoom user? Good morning, ma'am.
Good morning.
Are either Mr. White or you and Miss Kim going to represent Miss Farmer?
Judge, I can. My understanding is that her notice was returned. She never received it, so.
Okay.
That's what I'm showing, Your Honor. She had returned mail from 2900 Laurel Ridge Way, apartment 6106 in East Point. It appears she's updated her address. However, the updated address says 170 Plum Orchard and then doesn't have a city and just has the zip code 30016. So I'm not sure if that would get returned or not. And I would ask that she update it to her full address, because if they just put exactly what she put on there and send it in the mail, they may say unable to forward if it's not a full address.
Well, that sounds like a clerk's error too, because it's not like she goes in and usually you tell them in front of them and they type it in the computer. So.
Well, I'm not sure how it works, but they have a
normally they write it out on a piece of paper and we
it's a handwritten, yeah.
But
does the clerk write it or does the defendant write it?
Defendant write it out. They fill out a form. I'm looking at the form now.
Yeah, that's what I was looking at too.
Well, just make sure we have her address. We can make sure she properly gets notice. So, Miss Farm, are you still at the Plum Orchard address?
Yes.
Okay, give me that full address, please.
It's actually no, I'm actually at 115 Gumtree Trail. Gumtree.
If I asked you if you were at a Plum Orchard address, why would you say yes if you're not?
It's the next neighborhood, so we just moved, so I had to update it.
You moved in the last week?
I'm sorry?
You moved in the last week? Because you updated, that was your address as of the 19th of September.
Yes, I did.
Okay, so Miss Farmer, go ahead and put into the chat for me your full address.
It's 115 Gumtree Trail, Covington, Georgia, 30016.
Can you type that into the chat now? You know how to type it into the chat? So I can have it, the correct spelling of everything, so it won't be an error on our part. You know how to use the chat?
I'm not, let me see.
Go to your phone and it has more on there and it has chat and you'll see the names, you just chat and you just type your number information in.
It's sent to everyone. So
Yeah, just send it to everyone, that's fine.
okay. Okay, I updated.
What's the zip code?
30016.
Put that in the chat too for me, please. Okay, so we'll update that. Let me just say, Ms. Farmer, it is your responsibility to make sure that the court is aware of when you move. The first thing that you should do is notify the court when you move so that you can get proper notice. I'm gonna set aside the warrant this time as that's my usual custom. If you miss court again, it won't be set aside the next time. You understand?
Yes, sir.
All right. Anything further of Ms. Farmer this morning, Mr. White?
No, Judge. I'll get you
Can
set
I
aside.
ask her, excuse me, can I ask her, is this a house or apartment? I want to make sure people don't forget their apartment number.
It's an apartment.
What's the apartment number, ma'am?
It's apartment A.
See?
A is an apple.
Okay, so this is where you're gonna get your notice from now on. If you miss it again, another warrant's gonna be put out for you. You understand?
Yes, sir, I do. So there'll be another court address sent to the address,
Yes, you'll get notice of your next court hearing.
and the warrant will be set aside.
Yes, ma'am. We'll have the warrant set aside.
Okay, thank you.
Okay, any other questions?
No, sir.
All right, you have a good day, Ms. Farmer.
You as well.
I'll get that set aside.
I'm sorry, Judge, for interrupting like that, but most of the time they'll just give us the address, as you can see, and they don't give us apartment number, and I have to verify if it's a house or an apartment.
I understand, Ms.
And they still
Lewis.
won't get
I
their
appreciate
notice.
you. Appreciate you doing that. Thank you. Let's see. Desmond Sellers. Can you you couldn't hear me last week. Can you hear me today? Have we heard from Ms. Fagan?
Hello?
Yes, can you hear me, Mr. Sellers?
Yeah, I can hear you.
Okay, have you heard from Ms. Fagan?
I heard from her yesterday.
Did she say she was going to be with us today?
Yeah. She's supposed to be here.
Okay, all right. So, Ms. Lewis, I know that we've got some notices from Ms. Fagan in the past. I don't see that we've received anything today. Do you have her number that you can call her to say that the court's waiting on her?
Okay, I'll get Mr. Jordan to try to help me assist me with that.
Okay, I appreciate it. Mr. Sellers, you might want to try to call her too.
I'm gonna do the same thing.
Okay, thank you, sir.
I'm gonna stay.
Ms. Lewis, are you still with me?
Yes, sir, I am.
Given that we only have a couple more, whenever you're ready.
I'm trying to get my updates now.
Okay. Just let me know when you're ready.
Okay, give me 1 second. I want to make sure I got everybody correct. Everybody ready to go over the calendar? Y'all can let me know if if y'all waive the arraignment, because I don't think I got a chance to write everything down, but y'all let me know. We can start with the add-on calendar. Position 1, I'm still gonna be waiting on the order to amend the current sentence, Mr. Green. Position number 2 is gonna be reset to October the 3rd. I think Mr. Bartel, you told me to the competency counter for 11 o'clock for the 2 add-on for Mr. Brown, or just gonna be on the regular counter? You're on mute.
Yeah, I'm sorry, it's kind of hard to unmute.
It's okay.
Yeah, on Mr. Brown, he's number 3 through 7 on the state all-purpose, and also add-on number 2 on state all-purpose. That's to the 11 a.m. calendar on the 3rd. Yes,
All of his cases gonna go to the competency count for 11.
3, 4, 5, 6, 7.
Okay, I just want to make sure I got that correct. Okay. Position number 3 is the amended bonded order of the bond to a $6,000 SOB through the jail. Reset further notice. I did receive that information. I will be sending it over shortly to you for a signature, Judge. Position number 4 is reset for trial further notice, waiver arraignment by Ms. McLeod. And number 5, Ms. Angela Morrow, we're holding for her to enter her plea. Position number 1 on the regular counter was a plea. Position number 2, I have waive arraignment, reset for trial further notice. Position 3, 4, 5, 6, and 7. And 7, all is going to be reset to the competency counter for next Thursday, October the 3rd. Position number 8, Ms. Kim. I don't know.
There was PD White.
Oh, that's PD White.
It was a waive.
It's a waiver arraignment. Okay. You said for trial further notice.
Yes.
I guess you guys gonna have to tell me half of these. Position number 9, the same announcement. Waiver arraignment, reset for trial further notice. Position number 10.
It's a waiver.
Thank you. Same announcement. Position number 11, Christine
Waiver.
Collins. Waiver, thank you. Position 12 and 13 was an Alford plea. Position number 14 was a plea. Position number 15 is reset for the SAP October the 3rd. Position number 16, waiver arraignment, not guilty, reset for trial further notice. Position 17 was a plea. Position number 18 is going to be reset for, Michael, did I get that on the 18? I think we made it. October the 1st SAP. We need conflict attorney assigned. If I'm not correct on October the 1st, it'll be October the 3rd. I think we made that one. September the 19th, I'm sorry. Position number 19, it was a plea. Position number 20, defendant waiver arraignment. Reset for trial further notice. Same announcement for 21, waiver arraignment. Reset for trial further notice. Position number 22 was a plea. Position 23 was a plea. Position 24 was a plea. Position 25 was a plea. 26. Somebody say something? Mr. Seller. Position number 26 was a plea. Position 27 is reset for, it's going to be reset to October the 3rd. I'm sorry, because we couldn't get on October the 4th. Mr. Jordan had already set the counter out.
First, please.
I have to do a whole new add-on counter for that, Miss, and
because he's almost like time served. It just there's
I got it, Miss Kim. It's just that it's just complicated due to the storm. Nobody's working at all tomorrow.
Okay.
And
he's got a hold too for no bond, and he's got a hold out of Smyrna. So I mean Thursday it shouldn't be a big deal.
Yeah, I appreciate that. Position number 28, what's the announcement?
28 is a waiver.
Thank you. Position 29, I think waiver, we set
Yeah.
further notice for trial. Position 30 and 31, same announcement, waiver arraignment, we set for trial, further notice. Position 32 did make it on the October the 1st counter. So SAP reset. That was the only one. Position 33 is a plea. Position 34 is reset for Thursday, SAP October the 3rd. And position 35, same announcement, reset for October the 3rd, SAP. So that take care of everything. So we just got two pleas, one on the add-on and one on the competency count. Am I correct?
Yes.
That's correct.
And Ms. Kim, I am receiving your paperwork. Thank you. I'm gonna get that over. I guess I'm just waiting for stuff from Mr. White.
Thank you.
And I don't think I need anything from the ASG today. That's amazing.
Okay, thank you, Ms. Lewis.
You're welcome.
I see,
Thank you, guys.
I see that Ms. Fagan has joined us on Mr. Sellers. Good morning, Ms. Fagan.
Good morning. I apologize. I was still on Zoom with Judge Cox.
Not a problem, I understand. Let's see. Mr. Sellers is on our DV bench warrant calendar, and Ms. Desiano, I take it that Mr. Sellers missed a court date at some point?
Yes, Your Honor, he missed arraignment, Judge Morrison, on July 10th, 2024. And I see that Ms. Fagan did file a motion to lift the bench warrant. Apparently the defendant had court in the same day in municipal court as he did in state court, and apparently didn't realize that he had court in both places. And I'm just looking to see about his address because was there any returned mail?
I just got it.
Yeah,
Yep.
there is returned mail from 751 Fairburn Road, Southwest Apartment 3121, Atlanta, Georgia. And that appears to be the same address on his bond paperwork. So just curious why he's not, if his address is wrong or if he had court in multiple places or what happened.
Ms. Fagan?
Your Honor, I think that court is in multiple places. He just showed the court on his Zoom that he did receive the mail, so mail is good. That's not an issue in this case. But what did happen was that he did have court in two separate locations, didn't understand that, went to court in the other location, received a warrant in this location. We had another pending case with Judge Morrison. We went to court, we closed that case out, and then realized there was a bench warrant. Nobody arrested him at that time. Judge Morrison let me file the motion, and now we're here. And then I've been on trial for 3 weeks, so he's been on Zoom for 3 weeks.
Yes, he's been with us. Okay, so given the circumstances, we'll set aside this bench warrant. This court normally has defense counsel prepared. Are you able to do that for the court, Ms. Fagan?
Yes, Your Honor.
Okay, so if you're prepared to set aside, we'll set it aside. All right, you'll get notice of your next hearing date, Mr. Sellers.
And just send it to the office that sends the Zoom.
Yeah, you can send it to Ms. Katrina Lewis, who's on.
Got it.
Who's the litigation manager today, okay?
So he is receiving his mail because the return mail says unable to forward.
You just showed the mail for court.
It looks like it's coming late. So, and we all know there have been issues with the mail depending on
right.
where you. Okay, all right, Mr. Sellers, it will be set aside. If nothing further, y'all have a good rest of your day.
Thank you, Your Honor.
Thank you.
You're welcome. All right, so I guess we'll have to be in recess until we get one of these two other defendants this morning. So we'll be in recess. Unless somebody else has some business that they like.
That's it.
Okay.
ACDC, are you there? Are you ready?
Come on, Ms. Jones. Hi, Mr. Bartel. Hi, Ms. Luciano. Hi, Judge Moore. This is position 10 on the competency calendar.
Yeah,
Ms.
hi, Ms.
Cornetta Jones.
Okay. Good morning, Ms. Jones. Can you raise your right hand for me, ma'am?
Yes.
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, ma'am. Ms. Sessiano?
Your Honor, state's recommendation is 12 months served 90 days, credit for time served 21 days. That's from September 6, 2024 to today. Balance suspended. No further contact with Hanifa White. Stay away from 1 Margaret Mitchell, which is the Central Library, and comply with any MH treatment. We'd ask the defense to stipulate to venue, factual basis, and ID for purposes of the plea.
We do so stipulate.
Anything further, Mr. Bartels?
Well, Your Honor, I'll just let the court know, Ms. Jones was put on the 11 a.m. calendar because when she was to come out for court last time, she wasn't feeling well, and I think that might have been interpreted as some other issue. But I do believe she's able to enter this plea, so done to Ms. Burgess. So we would just ask the court to accept the recommendation. I advise Ms. Jones that by my calculations, serving 90 days, 2 for 1, with credit for time served 21 days, she should be out on October 20th.
Okay. Ms. Jones, it's my understanding that in case 24 CR 006323B, you wish to plead guilty to simple battery. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anybody forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Good luck to you, ma'am.
Okay.
Thank you, Judge.
Thank you. All right, Your Honor, Officer Deputy Francois is on her way to get Miss
Morrow.
Angela Morrow. So please be patient with us.
That's what we have this morning.
I can't say, Your Honor, I did see Ms. Morrow yesterday, and she's doing quite well. I think she's able to go forward with the plea today.
Okay, so hopefully we'll see her in a minute or two.
Okay.
Judge Morrow?
Yes.
Okay, we're
Thank-
ready. We're here for Angela Morrow.
Good morning.
Yes, good morning, Ms. Morrow. Can you raise your right hand for me, ma'am, please?
Yes, sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down, Ms. Morrow. Stesiano?
Your Honor, state's recommending 12 months, served 30 days, credit for time served 15 days. That's from September 10th to 2024 to today. Balance suspended. Stay away from Grady unless seeking medical treatment. We'd ask the defense to stipulate to venue, factual basis, and ID for purposes of the plea.
We do so stipulate. It looks like she's been in 17 days as of today, but I understand the offer is served 30 days and credit for time served. So I just wanted to.
Yes, thank you. This was a reset from Tuesday, so I didn't do the math. I'm sorry.
So we would just ask the court to accept the recommendation.
Okay. Ms. Morrow, it's my understanding that in case 24 CR 006377C, you wish to plead guilty to criminal trespass. Is that right?
Yes, sir.
Are you under the influence of any drugs or alcohol this?
No, sir. No, sir, I don't think I.
You've been represented by counsel. Are you satisfied with his representation?
Yes, I am. I'm very satisfied.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, I am.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated, Ms. Morrow. Good luck to you, ma'am.
Thank you, sir.
All right.
Thank you all. Thank you,
Good
Mr.
luck.
Ball.
Thank you, Ms. Mara. Good luck.
Okay, thank you.
Thank you, Judge Morrow. We're completed here.
Okay, thank you. Y'all be safe, okay?
Thank you. You do as well.
Okay.
Thank you, Judge. You too.
Thanks.
All right, we'll see y'all next time. Ms. Lewis, I've
I'm sending them as we can. Mr. Bartel, I need one more from you. I'm still seeking stuff from you, Miss Kim, I think.
Right, I've got Ms. Morrow's form to send.
Yeah, that's only what I think I need, and then I got the order from Mr. White. But I think we on track. I'm getting ready to send the Senate sheets over. I was just waiting for that last piece, send everything in order at once, Judge.
Okay, that's fine. All right. Y'all be safe. We'll see you next time.
Thank you, everybody.
Everybody,
Bye-bye.